People have been talking about the importance of the rule of law for thousands of years. In fact, the phrase goes back to Plato, who said the ideal society is one where the law is sovereign over the authorities and they are its humble servants. And of course, we all think that nobody, not even political leaders, should be above the law. But what does the rule of law really mean? We can all picture what a lawless society would look like, something like the Wild West, with vigilantes taking whatever they want by force or taking revenge on other people at gunpoint. The rule of law is supposed to put a stop to that sort of thing. It's a system that subordinates people's actions and the government's actions to rules. And not just any rules, but rules that people know ahead of time and which apply to everyone without favoritism or discrimination. Actually, this was a big deal to the ancient Greeks. One of the oldest works of Western literature is the Orestia by the playwright Aeschylus, and it's about this issue. It tells the story of Orestes, whose mother Clytemnestra murders his father Agamemnon. Orestes then takes vengeance on her by killing her, and the cycle of violence just keeps going on until finally the goddess Athena puts a stop to it. She declares that from now on, people will resolve their differences by following general rules, and crimes will be prosecuted through a trial where people will make arguments to a jury instead of just extracting vengeance however they want. Of course, this isn't just an old Greek idea. Every ancient civilization had basic rules that governed society. But that's not all that we mean by the phrase rule of law.
It seems obvious that when we say law, we mean a rule. But although obvious, that's a really important distinction between a rule of law society and a dictatorship. In a dictatorship, the government operates not by laws, but by commands, ordering particular people to do particular things.
Dictatorships are generally governed by commands, not by rules. There, everyone has to obey the ruler's will, so there aren't actually any laws because there are no general rules, no principles government must obey. Instead, there are just arbitrary commands. But laws are rules, which means that they're general. They apply to everybody under general circumstances. If there's a stop sign at an intersection, everybody who comes to that intersection has to stop, not just one particular person. That's a rule. And the difference between rules and commands is important because you sometimes hear people say that law is just whatever the government commands or prohibits. That's not true. In fact, that idea is contrary to the whole idea of the rule of law, which says government itself must obey the law. Now, here's the interesting point. If not everything the ruler says qualifies as law, then that means some things the ruler says are law and some things the ruler says are not law. And that means there must be some way to tell the difference. That means law is actually something objective, not just whatever the government says. And if law isn't just whatever the government says, then there must be principles that limit what kinds of things government can legitimately do. In other words, the government can't just do whatever it wants or act arbitrarily. If it does that, then it's not obeying the law. That idea is part of the US Constitution. We call it due process of law, and it's found in the 5th and 14th Amendments. The phrase originated more than 800 years ago in the Magna Carta, when King John promised not to take away people's lives, liberty, or property except by the law of the land. In other words, the king was promising to obey the rules instead of acting like he was exempt from them. And that phrase, law of the land, eventually evolved into the phrase due process of law. What it means is that government cannot take away life, liberty, or property except for a legitimate reason. Politicians can't just take away our rights because they feel like it. There's another aspect to this too. Remember I said law is objective? It doesn't just mean whatever the government says it means. After all, if the Constitution says government can't take away your life, liberty, or property except through due process of law, and then the government can pass laws, couldn't it just pass a law taking away your life, liberty, or property? Of course not, because then the phrase would mean nothing at all.
If it's true that due process of law means that the law isn't just whatever the government says it is, then law also can't be vague. Vagueness is extremely dangerous in the law because a vague law allows the government to throw people in jail basically at any time for any reason.
As the philosopher Ayn Rand said, Dictatorships don't operate based on strict, rigid laws which are obeyed and enforced with rigorous military precision. Instead, a dictatorship has to be capricious. It has to rule by means of the unexpected, the incomprehensible, the wantonly irrational. For example, if the government outlaws antisocial behavior, as many dictatorships do, then it can plausibly accuse anyone at any time of antisocial behavior and send them to jail. Vague laws therefore give government immense power to blackmail people by threatening them with punishment at any time. But it's not just vague language that's a danger to the idea of rule of law. It's also entire concepts that are either so poorly defined that nobody knows what they mean, or that don't actually mean anything in the first place. For example, federal antitrust laws prohibit so-called restraints of trade. That phrase may not sound vague in a grammatical sense, but when you scratch the surface, it turns out that there really is no such thing as a voluntary restraint of trade.
The dictionary defines this phrase as an agreement to restrain or hinder competition in ways that would not have occurred if the market had been allowed to operate according to natural forces.
But if two people or businesses make an agreement not to sell something, that agreement is natural and economic forces, even if they're trying to drive up prices or squeeze out a competitor. After all, they're still subject to the forces of supply and demand, so it makes no sense to say they're restraining trade. On the other hand, you might say that every contract restrains trade. I mean, if I sell somebody my car, then nobody else can buy it, right? There's no such thing as a voluntary restraint of trade, so that term ends up meaning whatever the government says it means. People usually recognize that law must be objective, but they have a hard time understanding exactly how that works. Laws are made by people, after all, and they use language, which can sometimes be hard to define, and that leads many people to latch onto things that look like objectivity but actually aren't. Probably the most popular example of this today is what lawyers call originalism. Originalism is popular because it seems like objectivity, but it actually isn't. The idea behind originalism is that if you take a legal term, like, say, the word liberty in the Constitution, and try to define what it means, the best way to do that is to ask what people thought it meant when the Constitution was written. That sounds like an objective thing because you can look through old dictionaries or newspapers and ask how people used the word at that time. Some scholars even put together big statistical analyses about how words were used in the past. But that's not actually what objectivity means. When we define a term objectively, we don't ask what other people think it means. After all, that only tells you what other people think, which is subjective, not objective. Something is objective when its meaning does not just depend on a person's say-so, including people in the past. But originalism does depend on someone's say-so. It's asking what our ancestors thought a word like liberty meant, and then relying on their personal beliefs. But that's no different than saying that the word liberty means whatever the king thought it meant. That's not objectivity.
I mean, after all, if you were to get into a time machine and go back to 1780 to ask our ancestors what they thought the word liberty means, they wouldn't have gotten into a time machine of their own and traveled back to 1680 or 1580 to ask their ancestors what the word means. They would have given us an answer, something like the freedom to do what we want as long as we don't harm other people. But if they would give us that answer, why can't we get that answer without using a time machine? We can figure out what words mean without using some 18th century middleman.
Here's how one scholar puts it. The semantic content of moral kind terms is fixed and given not by historical context and conventional usage of the term, as semantic originalism argues, but by the nature of the moral object, a real entity making up part of the world. In simpler terms, when the law uses words like liberty or murder, those words refer to actual things in the real world, just like the words fire or baseball do. It might seem strange to think that a word like liberty refers to a real thing in the real world because we think of it as a man-made thing, but baseball is a man-made thing too, and when we use that word, we mean an actual game, not just someone's personal attitudes. That's what objectivity is, and it's not originalism. There's another threat to the rule of law out there, and it comes from too much law. If there are too many rules, and they're so complicated that nobody can understand what's allowed and what's prohibited, then even if each particular rule is clear, the result will still be so confusing and complex that it becomes subjective. Not only would you have to hire a lawyer to even figure out what's permitted, and that's too expensive for many people, but even the lawyer can't really give you the answer. In societies where there are too many rules, the only way people can do anything is to bribe the government or get favors from politicians so they get exemptions. In other words, when government imposes too many laws, it ends up not really having a rule of law at all. Nobody really knows how many laws we have in the United States today. The US Code alone is more than 60,000 pages long, and then there's also the Code of Federal Regulations, which is more than 86,000 pages long and getting longer every day. On top of that, there are state laws and regulations, and city and county ordinances. There are also rules imposed by other government entities like so-called special districts. And then there are other kinds of rules like guidances and memos from regulatory agencies. The result is that nobody really knows what the rules are for most things. When the Constitution was written, James Madison said, "It will be of little avail to the people that the laws are made by men of their own choice. If the laws be so voluminous that they cannot be read, or so incoherent that they cannot be understood, if they be repealed or revised before they are promulgated, or undergo such incessant changes that no man who knows what the law is today can guess what it will be tomorrow." As politicians pump out law after law and rule after rule, it's important for us to ask ourselves whether we aren't actually destroying the very principle of the rule of law.